we're all realtors. We all know how busy things is, and we appreciate you all tuning in today and setting some time aside here to go over this. It's an exciting topic. Glad to host this with Jim. This is our bi-weekly webinar where we, one of your favorite sayings, iron sharpens iron, as we share information as agents, title company attorneys to help us get better and really differentiate ourselves as agents. I'll introduce myself. I'm Ryan Poole. Okay, I'm an agent just like you all, been in the trenches for over 20 years selling real estate. I'm also the founder of RealTrade, which is an online marketplace and social media platform for real estate. We just passed 800 agents. We have thousands of buyers and sellers. And of course, we have awesome service providers like Jim that use the platform to connect with you guys and help share information. One of the best things about RealTrade, I tell everybody, it's free to join for agents. And you know what? You get direct leads from your listings. So you can imagine that. You can actually get on there, take the 10 minutes, make a profile, and make tens of thousands of dollars. And we've had a lot of agents that has happened with. So
home of the double dip.
The home of the double dip, as Jim likes to say. So go ahead, Jim. I'm so excited to host this bi-weekly webinar with Jim. He has some awesome technology, has an awesome title company, and of course, his law practice. So go ahead, Jim.
So my name is Jim Brown. I'm the founder of Title Leap and the owner at New Path Title and James Brown Law. And today we are presenting open permits and how to navigate open permits and how to best deal with open permits, unpermitted work, and even some code violations that get treated the same way as unpermitted work. We're going to try to knock this out in 30 more minutes, maybe 45 minutes. If you guys want more time, you can always chime in. I'm happy to talk more. We're going to have question and answer at the end. If everybody feels comfortable and we have a small group and you wanted to turn on your cameras, it really helps to get the feedback. I love the journey of the agent. I was at the Florida beach. I was at the Palm Beaches. I was at the beaches seminar Friday for realtors, educating them on the new buyers representation agreements as a result of the Sitzer-Burnett lawsuits. And it was so nice sitting in the room with all the agents and seeing their faces and getting back in that pre-COVID groove. And I mean it when I say it. I really enjoy the journey of the agent. I love hearing about how you guys get your listings. I love hearing about, they're all like little novels. They're all like little stories. And I love hearing the stories. It never grows old to me. So we have, if you turn on your cameras, that'd be great. Question and answers at the end. Ryan and I will go over some time-saving tools that'll help you guys get in and out of your transactions quicker, help you get them to the closing table quicker. And you can text me. If you go to New Path Title, you can text me 24/7 with any questions you have, any transactional support you need. If you go to New Path Title, you'll see 24/7 attorney support. And you can also text us future topics.
I was going to say, too, add in there, if you have any questions as we go, if you don't forget them, put them in the chat, and we'll for sure get to them as well.
Thanks, Ryan. All right, without further ado, we are going to talk about open permits, the good, the bad, and the ugly. This is not a topic that's really well understood by agents. This is not meant to be demeaning to agents. It's just, I know agents personally that I've worked with for the better part of 20 years. I've been doing real estate transactions for 40, practicing solo for 20. They don't know what the rules are. And so let me put this on screen share, host disabled. Shay, could you patch in the screen share for us? Sorry, you guys. So.
Yep, go ahead, Jim.
There we go, screen share. Can you see open permits and unpermitted work?
Yep.
All right. And before I go on, we do the podcast, I always spend a little time going on social media to figure out what everybody's saying about a topic. So it helps me to hear what information is being spread about topics. Here's what I found. There is way more misinformation on the web regarding open permits than there is accurate information on the web. I even heard realtors who've been doing business for a long time telling people on YouTube that open permits aren't a problem. Open permits may not be a problem. Unpermitted work may not be a problem, but it's not been my experience that that's the case. So when you hear this stuff, you guys, pause, check yourself, pump the brakes, make sure you verify these sources. These are credible people that have been practicing for a long, 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 long time and telling you that open permits aren't an issue, right? It's only an issue. One woman said it's only an issue if the lender makes an issue out of it. So not the case. Generally speaking, open permits and unpermitted work. The main takeaway I want you to take away from today, 2 issues. Who's responsible for closing the permits? And are these title issues? They are not title issues. And the buyers and the sellers are responsible for closing open permits. And if the buyers and the sellers are responsible, by default, who do we know is responsible? Agents. Buyers and sellers just mean that becomes an agent responsibility. The confusion usually arises because the title agent may discover them in the municipal lien search and they distribute it to the parties in the same way they get the title agents distribute the title search. So then I get people calling me and they say, hey, it was your municipal lien search. You're supposed to fix it. We're going to go over why that's not the case. Not a title issue until they are ruled on by a judge or a magistrate and they turn into a lien. Generally speaking, a judge or magistrate doesn't give a ruling unless there is a health, safety, or life issue. Big takeaway, permitting is not a title issue, it's a party issue, and it never becomes a title issue until a judge rules on it and a lien results. So it lives in the municipal lien search report. Title issues live in, permit issues live in the municipal lien search report until a judge rules on them. A judge very infrequently ever rules on a permit issue. But if a judge does rule on a permit issue, then it migrates from the municipal lien search report to the title report. Now it's a title issue. Now it's definitely a seller thing that has to be closed before closing. When these issues come up, a solid issue knowledge of the rule will give you the edge over the other agent and make you look like the superior buyer, the superior agent to the buyers and the sellers. And I've talked to plenty of buyers that were represented by their agent and they call me after the closing. The buyers call me after the closing and they say, wow, that seller's agent was so sharp. You know, when we do this again, we're using that other agent. So every, you know, I don't need to tell you guys this, every transaction is a marketing opportunity for you. You could be representing the other. I've seen it before. You could be representing the other agent if you demonstrate stellar knowledge in the transaction you're in. It doesn't mean you throw your client under the bus. It just means you use the tools we've talked about to narrow the issue and get the goal. And the goal is the closing. And we've done other podcasts on how to narrow the dialogue. It's called IRAC, Issue, Rule, Analysis, Conclusion. It's just a frame of thought. Issue, rule, analysis, conclusion. It's a frame of thought for you guys to organize your arguments in to get your clients corralled into the goal. We'll go over that in another show. When analyzing an open permit or unpermitted work issue, always start with the contract. Here we're using the 723 FRBAR as is form. So whenever you have issues, you always want to go, there's what's called authority, and then there's the hierarchy of authority. Contract is the primary authority. If the contract doesn't talk about it, federal law would be the next authority, state statutes would be the next authority, ordinance would be the next authority, case law would be the next authority, but your contract 99% of the time has everything you need to know. The first place the permit issues are contemplated in the contract is in paragraph 10B. If seller has knowledge, seller must disclose to buyer in writing all open permits and unpermitted work. It's really simple. And sellers tell me all the time, not all the time, but I used to hear this a lot. Sellers tell me, well, I'll just go get another agent. No, you have knowledge. Once you have knowledge, getting another agent doesn't fix it.
Johnson v. Davis.
Johnson v. Davis. And sellers tell me all the time, how does anybody know what I know? Right? How does anybody know what I know? How can they prove what I know? It is so easy to prove what sellers know. How? You file a really cheap lawsuit. They're extremely inexpensive, and you send out requests for admissions. And in the requests for admissions, you ask the seller who worked on the property or what did you do or blah, blah, blah. And then you identify all the parties who assisted or had knowledge. And you just ask those people in the same document, in the same litigation transaction, What did they tell the seller? In 2 or 3 weeks, you know exactly what the seller knew, no matter what the seller tells you about them not being able to figure out what you knew, because there's no roofing contractor that's going to take a dive for a seller. So the moral of the story is, if there's unpermitted work, best they disclose. And when they say, how do they know what I know? It's easy for anybody to figure out what you know. It's a really easy thing for parties, buyers to do. So if the seller has knowledge of the unpermitted work or the unpermitted improvements or issues that were done without open permits, without properly closed permits, then the seller must disclose that to buyer in writing. And you use the contract as your friend when you're dealing with your seller, right? The contract's not the enemy. Your knowledge of your contract is your strength. It's your superpower. And you show the seller the provision in the contract. And it's not unique to you. Every single seller on the planet is going to have to comport with the same contract form. If sellers don't disclose and they have knowledge of the issue, which is easy to prove, sellers will ultimately be liable for the cost and responsibility of closing the permits. And sometimes we're going to go over it at the end of the show. Sometimes this stuff can be huge. When agents are on a listing appointment, look around, see if you see new windows, roofing, water heaters, etc. Ask if permits were pulled, and always ask if work was done without permits. By this seller or a prior owner. Ask by this seller or prior owners. It never hurts to ask, right? Here's what I always say: the devil you know as early as possible is the best devil, right? You never want this stuff popping up at the end. And I talked to an agent yesterday. I was giving him some advice on a really delicate transaction. And I said, you want to know this stuff as early as possible. And if I'm lying, I'm dying. We spent the whole morning working out this transaction. And you know what happened in the end? The seller said, oh, this is too complicated. I don't want to do it. Had they waited until the end to disclose it the way they wanted to disclose it, this thing would have boomeranged right before the closing. The seller didn't want to go through all these gyrations the buyer wanted to go to, and the realtor wanted to handle it a certain way that would have not put this on the seller's lap until the end, and the seller would have canceled. They would have been furious or canceled. And so, does anybody want to derail a deal up front? No. But do you want to put the issues on the table so they can be dealt with up front? And if you're going to have, fatal problems, deal with them up front and get another buyer? Absolutely. Absolutely. You just don't want to get all the way through the process, get to the closing table and have the thing boomerang and then have to go back to market. Mm-hmm. Inspectors are getting savvy. Buyers are making issues out of unpermitted water heaters and asking for closing credits. I just had a little house I put on the market. We renovated to the bare walls, put it back on the market. We had a couple little permitting issues. We used a licensed general contractor, but this buyer's agent hired a savvy inspector, and they were asking us questions, and we had to have great answers because not all the permits were closed. They'll be closed for closing, but we had little crazy things come up. Like when we were closing the permit, the municipality failed initially to properly evaluate the finished floor elevations. So the finished floor elevations have to be above the crown of the road, the high point of the road. So we go to close this seemingly incredibly easy permit to close, opened by general contractors that should never have had an issue. And now at the last minute, we're scrambling because the finished floor elevations are actually a little bit lower than the road in the garage. And so now we have to put what's called, Ryan, what's it called where you put the little dam in the wall so the water can flow out of the garage? It's like a flood dam. We have to put we have to put a flood dam in the garage last minute. But
they call it scupper on a boat. They call it scupper on a boat.
Scupper on a boat. So we had to do two things. We had to run down the street and take shots with the surveyor of the elevation of the road, looking for a point in the road where the road was lower than our finished floor. And then we had to install a flood dam in the garage to meet the code. Point is, right, this is a seemingly easy permit to close. There is no such thing anymore as a slam dunk. Yeah. Even permits that were applied for properly can have closing issues. And we'll go into why post-closing permit closures can be an issue in a minute. Inspectors are getting savvy. I've had inspectors walk through properties. The seller calls me or the buyer calls me. We're representing the buyer, and the inspector has an iPad on their hand, And as they're walking through the property, they see a brand new water heater, and they immediately go to the iPad with the City of West Palm Beach permitting page open, and they see there's no water heater permit. It takes 2 seconds, and they're turning that into issues. Use the FRBAR as your friend, and use that, I won't say against your sellers, but that just, it's your friend, it's your tool, use it. The second place in the FRBAR, I'm going to give you guys the outline after this, so you don't have to take notes and you can make all the references and look up all the provisions in the FRBAR. The second place that permits come up in the FRBAR is in 12A, paragraph 12A. This is the section about inspections. And so to be a thorough buyer's agent during the inspection period, if you want to be the super thorough buyer's agent during the inspection period, ask the inspector if they saw any recent improvements that were not made with permits, and ask the seller if they have any knowledge of this. So you're going to put in writing to your inspector, did you see any? And I know plenty of agents that go out and meet all their inspectors on site, and they just follow up with a little email as they're sitting in their car after the inspection, and it just says, did you see any unpermitted improvements? What did you do? You just did 2 things. You put the buyer's inspector on notice that you're knowledgeable, but you also, as importantly, just absolved yourself of liability.
Like that. That's great, Jim.
So there's a little document trail of you asking the inspector if they saw any unpermitted work, any new improvements that possibly didn't have permits. Now you've fleshed it out. If there's something, they're going to mention it. If there is nothing and it comes up later, you did the most thorough thing you could do as a buyer's agent, and you put that issue on the table. So they could never come back to you and say you didn't do your job. We don't want to spend all our time covering our tracks, but we have to be proactive in our liability. Unfortunately, I've seen a ton of liability management lately that could have been nipped in the bud had people been asleep at the wheel. I mean, been awake at the wheel, myself included, right? There's so many issues. Being a realtor is not an easy job. It is federal laws, state laws, contract laws, lenders regulations, inspections and code inspectors. And, and then on top of that, the contract form itself, changes in the NAR and the sites are Burnett. And, being a realtor is incredibly difficult. All you have to do is issue spot, though. And if you can spot the issues, you can call me or you can text me, even better, and we can go over what the answers are. No one wants to upset a deal, but I've seen many a realtor get drug into a lawsuit. I don't want to even go there, but we've seen several lately where there was issues that were, I mean, I can give you a real obvious one. There was out-of-state people had the buyer's agent do the walkthrough inspection.
You mean the final walkthrough?
Never do a walkthrough inspection for your buyer. Tell your buyer, get your inspector. They know the property condition better than me. Sometimes inspectors will do it for free. Sometimes they'll take a little bit of money. I don't see a ton of faces, but if anybody has a comment on this topic, I'd love to hear it. But I've seen agents do walkthrough inspections, and post-closing, the property had numerous unpermitted gas plumbing for the stove and things like that. Like literally, they came to energize the house with gas after the closing. You could hear the gas escaping in the walls. Is the realtor responsible for that? Absolutely not.
So just to be clear here, you're talking about like there's been buyers that have asked the agents to do the inspection for them, like the primary inspection.
I've seen
like
3 or 4 of these in the last several months.
Holy
People
smokes.
texted me. But the problem here was, right, you do a walkthrough. Nobody turns on the gas to see if there's going to be gas leaks. You would never do that as a realtor ever anyways. But the buyer had the out-of-state buyer. They were a flipper. They did a ton of properties with this agent. And then they closed and they came to energize the stove, and there was gas escaping in the walls in numerous locations. And who are they going after? They're going after the agent. Why? Well, they're going to, all the obvious, but that agent happened to do that walkthrough. And the easy answer is always have your building inspector, if you can, tell your buyer to get the building inspector to do the walkthrough. Third place, building permits are, let's see, the best time to sort out. Okay, so the best time to sort out permit issues is during the inspection period, but they can be sorted out any time if the seller had knowledge and they failed to disclose. Permit issues don't die at the inspection period. If the seller had knowledge and they failed to disclose, permit issues survive the contract. The third place permits are contemplated in the contract is 12C. Here, the buyer, not the seller, as you might expect. Remember, we're talking about the Florida FRBAR, the most recent version, is responsible to close out building permits. I'm sure everybody's aware of that. I just want to say it again. I see seasoned agents that believe that the sellers have to. We had a transaction we were doing for a North County realtor. They've been doing this stuff longer than me, and there was a permit issue and they're scrambling to close this permit. And I talked to one of the processors and they said, oh yeah, the seller's agent is scrambling to close this permit. It was a buyer's agent duty. It's in the contract. You would be amazed how many seasoned agents. Yep, we talked about that. I've even seen them get into in this one particular transaction. Sorry, Ryan, but I saw this buyer's agent who was responsible for closing the permit attacking the seller's agent, and the seller's agent scrambling to line up the inspections, not knowing it was the buyer's agent's responsibility.
Well, this is where they protect themselves with the buyer's agent. This next here on paragraph 20, this verbiage, I use this, guys. This is something that I add to all my contracts, and Jim's going to share his legal.
Yeah, so you'll get this after the closing, and I actually modified this right before the show because I even thought of things that I have encountered in between last time I wrote this paragraph and this time I looked at the paragraph. Seller shall close. So we add this to paragraph 20 when we're representing buyers.
Yep.
Seller shall close all permits that are open, inactive, revoked, pending, expired, or otherwise closed. It's not enough to say they're going to close all open permits, right? Because I've had arguments come up where the buyer's agent, where the buyer's attorney said, well, we have inactive, revoked, pending, expired. Like every municipality calls it a little bit different. So you have to like call out all those particular terms because people will figure out ways to escape the responsibility. So you have to make sure you identify all the little nuances to the best of your ability that are going to get your client out of the issue that they're jammed up in. Okay, so then this was the one, obtain permits for all. So seller shall close all permits that are open, inactive, revoked, pending, expired, or otherwise not closed. Obtain permits for all unpermitted improvements occurring during or prior to seller's ownership, and resolve, pay off, and close all municipal, county, homeowners, and or condominium association violations, if applicable, prior to closing at seller's expense. The thing that I just added before the show was occurring prior to seller's, occurring during or prior to seller's ownership, right? And that was only because we just had a case recently, and I want to give you guys the benefit of that knowledge. We had a case where the unpermitted improvement was several owners prior to the seller, but the seller had knowledge. So we'll go over some statutes as to how these become easier to close in a minute. But if the seller has knowledge, even if it was a prior owner, they still have that knowledge, even if they didn't do the unpermitted improvement. Does that make sense?
Yeah. So this, just so you know, this paragraph 20 would supersede then the earlier part of the contract where it was the buyer's responsibility, right? That they're taking on that responsibility of the open permits. I mean,
good point, Ryan. So whenever you write something in a contract, the written in provision is controlling over any pre-printed provisions. And there is a statement in the contract form on that topic, on that issue, but anything you write in by hand supersedes, precedes, it contravenes, it now becomes the controlling issue. And that can be good and bad, right? There are times that you want to add something to a contract to add an additional point.
Yeah.
But I just want to mention something, and I saw this the other day. Agents who don't know what the contract says write something into paragraph 20 that actually narrows the provisions protecting their client. So what I saw the other day was it said that the seller will pay, well, what they meant to say was, I don't remember exactly what the issue was, but what they meant to say was that the seller is going to pay a certain area of special assessments. But what they ended up doing was roping their client into paying all the special assessments. and they didn't distinguish between special assessments from a municipality and special assessments from a homeowners association. And in this particular transaction, there was in Delray, there were street improvements for municipal assessments, which aren't homeowners association assessments, which is what the agent meant. Both issues being tackled in the contract, the agent now wrapped their seller into paying for the special assessments imposed by the municipality.
Yeah, I mean, they walked themselves back into an issue. I mean, hey, Jim, we're going. This is getting into the meat and potatoes, guys, of the webinar of our podcast here. We got a couple questions, Jim. And they're really pertinent ones, so we want to get.
Go ahead.
Jorge asked, what if the seller doesn't have knowledge of improvements, or unpermitted work prior to when he bought the house, right? So, and then they also ask a question, can we use that clause that you just shared and add it to our contract in additional terms? Can we use this? Second part, for sure.
This is what I use when we represent buyers. I'm sharing it with you guys. Am I going to tell you?
I use it every time. I realize now you added more verbiage there, but this is really important if you're representing the buyer. Because as we stated, which Katie had a question, she goes, just want to make sure I heard this correctly. If there are open permits, it is a responsibility, according to the buyer in the standard contract, of this buyer's agent to handle. But if we add the verbiage you just spoke about in paragraph 20, then it becomes the responsibility of the seller's agent.
Correct.
Yes. So guys, this right here, okay, if you add this to your contract when you're representing a buyer, you are a hero, okay, if there's issues that come up on the permits. And I've had it happen. I've literally had it happen, and the buyers were protected just by the simple verbiage that Jim just shared with you. He's added a few things in here, but this is a great tool. This is
I can't get to the screen share for some reason. Let's see, here it is. I want to address another question. Can you guys see the contract form?
Katie, does that answer your question? Katie, you good?
All right. So everybody should know this like the back of their hand. I'm sure I beat this drum. There's two drums I always beat. One of them is going to be what Ryan said earlier. Seller's disclosures. Three issues when a seller has to tell a buyer what they know. Seller's disclosures. They're in the contract. The rule is called Johnson v. Davis. Seller knows of no facts. That's the first issue. If all these three things are present, the seller has to tell what they know. Seller knows of no facts materially affecting value, which are not readily observable. We can go into more detail in another show, but if those three things are present, if the seller has knowledge, it materially affects value, and they're not readily observable, then the seller has to tell the buyer what they know, and going and getting another agent doesn't solve the seller's problems, and it should be in writing. Yep. And you want to use the contract as your friend, right? You know what the contract says, you bring this to the seller's attention, and that's how you get your problem solved. You don't try to convince the seller of anything, you just say, this is what the contract says, and this is what we have to do. That answer your question? So if it's okay, so here was your exact question, I think. If it's a prior seller and prior owner, and the current owner doesn't have knowledge of the unpermitted improvements, which is legit, right? Yep. People, I've seen it all the time. They convert their garage to a bedroom. It's obvious to me, but the seller didn't have knowledge. They're not a sophisticated seller. They don't have to disclose it. Yep. The problem arises when the lender says, hey, we just had this come up the other day. The problem arises when the lender says, hey, we're lending on a 4-bedroom, 3-bath, and this is a 3-bedroom, 2-bath. Yep. And now the property didn't appraise. The buyer went out, and the property didn't appraise, and the transaction ended up closing. And now the buyer is going back and suing the seller. They can't close for cash. It's a big mess. 2 years later, they're still in litigation, but they'll get it done. It's just, everybody had a whole lot of unnecessary involvement. Let's go back to the screen share on our outline.
Mm-hmm. Ronald had a quick question. Suggestions when there's an old open permit and the work was never done, either work was canceled or contractor took the money and run. What is that issue? If there was, I guess, so there's an open permit that nothing was done, right? So, I mean, I guess they go and just cancel that permit.
Well, there's a couple of new laws we'll go over in just a minute that are going to get you to that goal. really
Okay.
good laws that they just recently enacted in the last couple of years. Can you guys see the outline, or are you still looking at the contract?
We're still looking at the contract.
All right, screen share. Outline, sorry about that. So just like the contract, the standard form seller's disclosure has a provision requiring the sellers to report open permits and unpermitted work. It's in the seller's disclosure and the contract. I'm not a big fan of seller's disclosures for numerous reasons, but some brokers make you have them. Parting thoughts, we're at 30 minutes. Open permits are not typically title issues or marketable title issues. They are typically contract issues. Because they are contract issues, they're resolved by the parties. Because they are a party issue, we all know what that means to agents. They're handled by the agents. However, an open permit or unpermitted work can become a title issue, although not often, if there is a municipal violation notice posted on the property by a code enforcement officer. The only times I've seen this is for life safety and health violations, like we talked about earlier. A violation hearing by a judge or magistrate is held. An order at that hearing imposes a lien, and that lien is entered into the public record. What happens when that lien enters into the public record? It goes from being a municipal lien search report issue to going into now being a title commitment issue. So now it just crossed the magic threshold, right? Nobody addressed this in the contract, but now it becomes a seller's issue instead of a buyer's
So
issue.
let me just stop you right there. Okay, so let's say they have a garage that they converted into a fourth bedroom, right? I've had this happen before, and it was unpermitted, right? And the new buyer's trying to buy it. They could still get title insurance on that home, even though the garage is now converted into a fourth bedroom, because it has not been, by the magistrate. They haven't held a hearing on it. So it's still insurable at that point.
Yes. Title insurance doesn't insure, generally speaking, title insurance doesn't insure two things. It doesn't insure sticks and bricks, and it doesn't insure access and egress.
Mm-hmm.
So title insurance doesn't guarantee you can get on and off your property. And that doesn't come up much in our properties, and comes up a lot in equestrian communities and homes out west and Calusa and things like that. But title insurance doesn't guarantee you can get on and off your property. Title insurance also doesn't guarantee that you're buying the 4-bedroom, 3-bath that was advertised in the listing.
Unless there was some kind of violation, right? Then it becomes.
Well, so title insurance would never insure the size of the structure or the nature of the structure, but it becomes a title issue. A title insurance commitment is like a roadmap to closing. If you ever look at your schedule B1, you're going to see B1 is a whole list of things they call requirements. Requirements are the things that title agent, we have to do when we're going to close a transaction so that it's an insurable transaction. If there's a code violation for an open permit, we're going to go over an example in a minute, then that has to be closed as a function of the requirements.
Got it.
Here's where it gets a little bit confusing. Don't commit this to memory. But if you ever have a transaction where the buyer says, I want it, I want it, I want it, the title agent can move the requirement from the requirements to the exceptions. And then you can close. And everybody's on notice and no one will have a problem. What does that mean? So if you had a property with a balcony that was shaky, this is an actual example we'll go over in a minute, and the property had a code violation and the buyer was going to tear down the balcony anyways. They built a second floor balcony, it had wood and the joists didn't have any diagonal reinforcements. So when you walk on the balcony moved back and forth like that. It was great. It was a bunch of young people. They loved the balcony. But the buyer was coming in, it was a Lake Worth property, they're going to tear off the balcony. So I told the title agent, we represented the buyer in the transaction. Property had an ongoing code violation, and we told the for health safety and life health safety. And so it was a requirement that the open permit lien, the lien resulting from the open permit, be closed. We had the seller pay for the closing, we had the seller pay for the fines, but we took title because we couldn't fix it before closing with the violation.
Got it.
So as soon as we closed, we paid off the fines at closing. As soon as we closed, The buyer did their due diligence and they told the magistrate, or they told the city inspector at Lake Worth, who can be not the easiest to deal with. As soon as we close, we're going to tear this thing down. In advance, they got you have to get, don't forget, you guys, and I've been guilty of this myself. If you're going to do destruction to a property, if you're going to do demolition, you got to get a demolition permit. So they lined up a demo permit ahead of the closing. As soon as they closed, they paid off the lien and they demoed the balcony at the day after the closing, or whatever it was. They had a crew lined up and everything was seamless. It took a lot of little orchestration of the parts, but everything closed seamlessly. And then but the point is, we moved the requirement to close the violation from the requirements section of the title insurance commitment to the exceptions section. Now the buyer could never go back and sue on the title insurance policy for the permit issue. Does that make sense to everybody? It's relatively complicated, but
Yeah,
if it doesn't,
yeah.
don't hesitate to just say, can you go through that again?
Yeah, George Alvarez had just had, what if the seller and buyers agreed with the seller concession of a certain amount to do a preconditional reoccupancy and buyers get responsibility of closing permit? Is that acceptable to title insurance? It happens very often in Miami.
I think we're going to go over that in a second.
Okay, good.
And when I go over it, if I don't cover it, just say, hey, it didn't fully cover it.
Okay, let's keep going.
So what happens if there's a violation posted and there's a violation hearing by a judge, the judge imposes a lien and the lien goes in the public record and that becomes a title issue. These liens can become huge money. James Brown Law handles these permit lien and code violation issues. How do you close open permits and unpermitted work? First thing you do, contract the city municipal inspector and have them come out and re-inspect the property. You got to use a little bit of common sense. Sometimes you don't want the inspector coming out. Sometimes the violation or the unpermitted thing is so egregious, you know there's huge problems. So you got to use a little bit of common sense. You don't want to bring your inspector out to look at a property for the initial inspection. I did a commercial transaction over on Military Trail for a used car lot, and the wiring was just a disaster. If you bring the inspector in there, you know what's going to happen. It's going to be a disaster. So the first thing we did was we did things a little backwards. We got a unpermitted work for the for the wiring was never closed. We had a electrician go in there and look at it. In that particular transaction, usually you just bring the code inspector out there if the roofing permit was never closed or something simple like that. So you get them to take a look at it, you give them a little work plan and a scope of work of what's needed to close the permit. Then you make any fixes, get any plans drawn, any structural engineers. You guys contact me. We got a whole battery of people we can turn you on to. We've been doing this stuff for years. I don't want any money out of it. I'll just hook you up with the contractors. You got to generate the plans, do the work that's needed to satisfy the permits. If unpermitted work is the issue, you'll need a GC or an engineer, a roofing GC or an electrician or a structural engineer. Again, we can work all those things out together. And then you get them out for a re-inspection after the work is done. These guys are your friends. These women are your friends. You would be amazed how far a croissant and a hot coffee goes when you're on site. And I can give you an example. We had a Riviera Beach property. Everybody on the street had uncut grass. My client was selling their property. They had a million, Tajay might remember this one. We had a million-year running lien for uncut grass. It was, whatever it was, $75,000. We get the code inspector out there. The client hadn't done a great job of resodding the lawn and making the landscaping appropriate. And there were still a couple of bald spots. And so the seller says, well, what about those guys right there? Look at all their bald spots. And what about that guy? And started getting all over the inspector. If I'm lying, I'm dying. The inspector opens the main doors in the back of the truck, grabs a little remote control, flies out a drone. First the inspector said to the seller, can I walk in the backyard and take a look at your appliances that you have on the patio? And the seller says, hell no, you're not going on my property. And so the inspector goes, okay, have it your way, tough guy, or something like that. And they open the van doors and a drone comes flying out and starts flying over the fence to the backyard. And the seller's like, whoa, wait a minute. He goes, all right, now you got two things you got to do. You got to move all your appliances inside and you got to resod your yard. And we'll come back here in a couple of weeks. My point simply is these guys are your friends. Use them to your advantage. They're your roadmap to a closing, to a commission. You want to make sure they're your buds, and you make friends with them. You'll do business with them the rest of your life. That's happened for me over and over and over. As a general rule, I hope this answers your question earlier. As a general rule, holding escrow to close permits post-closing can be dangerous and highly recommended. I highly recommend not doing this. And I highly recommend not doing this.
A quick butt into that. I mean, right now in our office, we have probably 2 or 3 files where, we held escrow back for a seller to do something. And we have one file, it's been a year, an absolute year. And they're still going back and forth about like, this hasn't been done correctly and the deck hasn't been fixed and all these different things. So I always tell agents, it's better you just give a credit at closing or don't close until it's fixed, because from an escrow side of things, it ends up being a very long. Sellers are not motivated anymore to get it done. They're like, you know what, we'll let the money sit there until we figure this out.
And then everybody has an argument over quality, right?
Yeah, like who decides the actual quality? Like who makes that last identifying, decision?
I'm going to give you guys two nightmare transactions that'll linger in your mind, hopefully after this session. Agent represented the buyer in the sale of beachfront multi-story $1 million townhome, back when 1 million was a lot of money for a townhome. And we've had a million of these since, but I'm just saying this is a big one that stands out. It's a few years ago, with an unclosed roof permit opened by a GC, right? GC does a job. How many times do they fail to close the permit?
Yes, had it happen.
A million times.
Yeah.
Sounds easy, right? I wish. The agent told everyone to escrow $5,000. They would close the permit after the sale. The agent heavily-handedly steered this thing. The inspector said the roof did not pass the wind lift test. A new roof was needed. A new roofing GC said the cost was $60,000. The building was 3 stories tall, and the seller was long gone.
Oh, he said he planned on losing that $5,000.
We closed in Ocala, several $1 million farmhouses, the one Tajay mentioned earlier. The seller's agent, before the show, the seller's agent corralled the parties. I think it was $10,000 in escrow for unpermitted entry monuments. Sorry, monuments, and a pool both installed by licensed contractors. And we closed. The inspector came out and all the improvements failed for multiple reasons, including the improvements were not built within setbacks. The buyer didn't want a survey. And the first thing they had to do, and the monuments cost $100,000, and the pool had to be rewired and plumbed. Tajay, did they have to tear out the pool, or did they let the pool fly?
Repeat that, I'm sorry.
No, I think they may even had that Ocala horse farm. Did they have to tear out the pool?
I think so. The buyer and the seller were both like contractors and ended up working it out between each other. Like they credited him a lot of money to take care of their issue for them.
I remember there was an estate and there was an issue about proceeds too, because as soon as the estate seller got the proceeds, I think there was family members with huge cancer bills or something. Anyways, it was a nightmare. So here's some recent, did that answer your question, Jorge?
And Jorge, I have one thing else to add about that, is that Jim reiterates this a lot to agents, but if you do a, hold money back, be very specific. Like we see a lot of addendums that come out and it's like, New Path Title will hold $15,000 until the roof permit is closed out. But there's no date, time, nothing.
Put a time fuse on it.
Exactly, time on it. After 90 days, who should get the money? When those things aren't determined in that addendum, it leaves it up to everyone's opinion on what should be done.
And on the 21st day, the seller, the title company is instructed to automatically pay the escrows to the seller, no further action of any party required, right? Everybody thinks if there's a failure in a contract, well, it's obvious, the buyer gets the money. And then they call me and they're like, what do you mean you can't just give the money to the buyer? The seller refused to close. No. Escrows only can be broken under 2 fact patterns. 1, the parties agree. 2, a judge orders. Those are the only times you can break escrow for anything. Now, we have had transactions where we have broken escrow. We had a transaction recently where a buyer put a deposit on a house. and a seller listed a property and the seller wasn't the true owner of the property. And then they went radio silent. Did I return the escrow to the buyer? Absolutely. We didn't have an agreement of the parties, but those are problematic transactions. And so you got to be really clear in your addendums so that if there's a failure of one side, the escrow agent is instructed to return the escrow to the buyer or whoever it is without any further action of the parties required. And then you do that with dates, like Tajay was saying. Before the date, it goes this way. After the date, it goes that way. All right, here's a outline. We're 45 minutes into it. I want to get you guys out of here. In 2019, a bunch of new laws were enacted, a bunch of statutes were refined, and this one isn't so important to us. It's more important to contractors. If the building permit is expired and the requirements of the permit have been substantially completed as determined by a local building agency, the permit may be closed without having to obtain a new permit. Prior to this law, you had to have a new permit. And then closed permits after the 6 years. This is the one that's going to affect us. Local government enforcement agencies may close a permit 6 years after the issuance of the permit without a final inspection, as long as the agency determines that no safety hazards exist. That would include work that was never started. You cannot penalize subsequent owners and contractors for work that wasn't closed under a existing owner. Local enforcement agencies cannot deny issuance of a building permit to an arm's length purchaser for value or legitimate purchaser solely because the permit of a prior owner was not closed. And we used to see this a lot.
Yeah.
Additionally, local enforcement agency may not issue a notice of violation, fine, penalize, or sanction, or excess fees against an arm's length purchaser for value solely because the permit of a prior owner was not closed. I've seen that frequently. And I've seen attorneys screw that up frequently. The issuance of a building permit to a contractor cannot be denied solely because the contractor is listed on another building permits that are not closed. And I've seen that. The conclusion, revisions to the statute, provide incentives and tools to make it easier to close open permits. I'm going to give you guys this outline. We're 47 minutes into it. Somebody has their hand raised.
Yeah, for cheap.
I am going to butcher your name, and
I know. I didn't want to.
But go ahead and ask your question and tell us.
You can ask this, unmute yourself. Go ahead, you can unmute yourself.
Yeah.
Yeah, we just lost you. Try unmute yourself one more time. There you go.
All right, well, she's trying to do that. Go ahead.
Some sounds
Now, you want to write it in the chat? We're only picking up every second or
I think
third.
she did write it. She said, when the prior owner has unpermitted work, what should the seller do? She did write that question, Jim.
Okay, so there has to be knowledge of the current seller for there to be a required disclosure.
Yeah.
And like we talked about earlier, proving what a seller knows is not tough to do. I'm going to give you in the outline, you're going to get these statutes, and I'm going to have Shay buff out the outline with some more references, so you guys will you'll get emailed what we talked about today. I want to close real quickly. Title advance, if you're not using them,
Yes.
They're saving buyers and sellers tons of headaches, and agents, they're winning listings with them. It's going to be the way business is done in the near future. Just go to titleadvance.io, order your title advance. There's 24/7 attorney support available to you guys. I picked up an agent in the north part of the state. They watched Tajay told me they watched a couple of our podcasts and they got some great advice, and now they're closing with us regularly, and we love that stuff. Title Leap saves you time. You close with us, you get Title Leap. I'm doing a transaction myself. My wife, she gets the messages. We love it. It's the greatest thing. Nobody even looks at their emails anymore. New Path Title, James Brown Law, we're here for you guys. You got eviction issues, foreclosure issues. Doesn't matter what it is. We're looking at
Open permit issues.
open permits. We're looking at weird stuff lately. People think they own property, they don't. People have bought houses and houses are not located on their properties. It all comes up. Yeah. Anything else you want to add, Ryan?
No, I just want to say, guys, I host this bi-weekly webinar with Jim, and as an agent, even though I've doing this over 20 years, I mean, even today, you learn new things, right? So that can help you on your journey. But I do want to say some great shout outs about Title Leap. Title Leap is a software that Jim's developed, right? That is almost like a free contract coordinator that you as an agent can use. It has all your drop dead dates, so there's no surprises. And another big thing, and it's free for us agents, right? Another big thing too is Title Advance. I know he's touched on it, but it can pick up certain title issues, especially if there's some, fines, from the local jurisdiction of some open permits, right? That they can come up. So you're aware of them, so you don't have that surprise in closing, as you get to closing, so you can address them prior to as well. So I can't say enough good things, Jim, about that. And hey, guys, check out RealTrade. Go to realtrade.io or just Google RealTrade, create a free profile. Literally doing that one step could make you tens of thousands of dollars. So you can get direct buyers and sellers that can contact you through the platform. Cool thing is you can use the social feature, help sell properties quicker, connect with awesome service providers like Jim. We have insurance agents, we have lenders, we have inspectors, we have appraisers, all those people that you need in your contacts, right? You can get contacted with them on RealTrade.
And in your title advances, you're going to get, if the municipality offers it, a summary of open permits.
Yes.
So we put, if the municipality posts it, we're going to list it, saves you a step and puts everything in one place. These are great conversations to have with your seller at the listing. You'll win listing appointments when you show up.
Every time I go to a listing appointment, I have a title advance with me, right? So I know what the issues is. You can notice there's a lien on the properties. If there's a mortgage on the property, how much it is, all those good things that you have is you feel like a knowledgeable agent walk into that listing presentation, especially if there's other agents that you're competing with. And it's free, guys. It's a free service that Jim does for you. So it's pretty cool.
If you don't have anything else, I would love to get your recommendations, the agents. I love hearing about the agent journey, right? I'm passionate about hearing how agents get to the closing table. Text me with future topics you'd like to cover. Ryan and I can come up with a million, but we'd love to hear what you guys want to cover. Other than that, sayonara.
Thank
Awesome,
you so
guys.
much.
You bet. Thanks, you
Thank you
guys.
so much.
Thank you.
Let's go get
Bye-bye.
them. Happy
Have a
selling.
good one.
Yep.
Happy Thanksgiving to everybody.
Yeah.
Happy Thanksgiving. Yes.
Very
Happy
good.
Thanksgiving. Thank you.
All right. Thanks. All right. Bye.
Let's see.
Jim, I have one question.
Yup.
Yeah, so I'm asking I want so
Your phone's going in and out. You want to call me?
the steps we have to do.
Call me right
Yeah.
after the show, because your phone's going in and out. I'm not picking up everything you're saying. 561-307-0885. I'll call
Okay.
you back. All right.
Bye.
Adios.